Broadcasting from Manhattan Beach and the World Wide Web, you're listening to CHSR, HealthyLife.net.
As a service to our listeners, this program is for general information and entertainment purposes only. CHSR, HealthyLife.net does not recommend, endorse, or object to the views, products, or topics expressed or discussed by show hosts or their guests. We suggest you always consult with your own personal, medical, financial, or legal advisor.
Bonjour. I address you in Potawatomi, the word for greeting, as I'm a registered member of this Native American tribe and our language is dear to us. My name is Randy Kwiatkowski. This episode of Indigenous Perspectives originates from the state of Vermont in the United States. This is not my tribal homeland. It is the unceded traditional territory of the Abenaki people, who for thousands of years were and continue to be stewards of these lands that they know as Endakina, which is to be found here in the state of Vermont, in the northeastern United States, and across the Canadian border in southern Quebec province. I begin by acknowledging where we come from, both culturally and geographically, as this program, Indigenous Perspectives, focuses on understanding our roots in Mother Earth and our connections with our ancestors.
And I'm Carolyn Schmidt, co-host, and we welcome Thomas Linzey to our program today on the topic of the rights of nature, bringing Indigenous perspectives into the legal system. Thomas Linzey serves as Senior Legal Counsel for the Center for Democratic and Environmental Rights, CDER, a nonprofit organization committed to globally advancing environmental rights. He is widely recognized as the founder of the contemporary community rights and rights of nature movements, which have resulted in the adoption of several hundred municipal laws across the United States. In 2008, he assisted the Ecuadorian Constitutional Assembly to draft its rights of nature provisions for the new Ecuadorian Constitution. His work has been featured in the New York Times, the Los Angeles Times, Mother Jones, Forbes, and The Nation magazine. So welcome, Thomas.
Thanks for having me.
Can you start by explaining what the idea of rights of nature is all about?
Sure. So rights of nature concepts have been around for quite some time, even in Western law, but most folks are still new at understanding what rights of nature means. And in a nutshell, what rights of nature means is that our existing way of protecting the natural environment hasn't worked. And that existing way of protecting the natural environment has essentially been about treating nature and ecosystems, mountains, rivers, as property under the law, something to be owned. And which has given birth basically to this concept that the more property you own, the more ecosystems you can destroy under our system of government. That's simple. And so folks have been looking around, and when I say folks, I mean mostly folks from the Western or European perspective, have been searching around for a little while for a new paradigm, a new system of environmental protection, which isn't linked to this concept that environmental protection should just be about regulating use of property. In other words, continuing to treat nature and ecosystems as property, but just seeing our role as just regulating the use of it for its owner. And so in Western law, the concept popped up in the 1970s, early 1970s. Of course, Western scholars who track this rights of nature concept back to 1970 are off base as well, because, of course, indigenous communities for thousands of years, many thousands of years, have treated nature as something other than property, something other than something that could be owned. And so indigenous communities talk about nature in terms of being an animated thing, being a relative, rather than European Western culture, which essentially treats it as this thing or property to be used, similar to the status of women in the 1820s, similar to the status of African Americans before the Civil War. that in those cases, people were treated as property. Today, there's probably no more theory more embedded in Western law that nature is simply property to be used. And in fact, you see that in our language. It's not just the law. We talk about land being undeveloped if it hasn't been touched by human hands. Well, that land is developed over billions of years ecologically from an environmental perspective, but our language doesn't respect that or doesn't reflect that. And so rights of nature is really this new doorway towards a new kind of system of environmental protection that recognizes nature as having these human civil rights type based rights. So we think about human civil rights all the time. We think about our U.S. Constitution Bill of Rights and our State Bill of Rights, and that people have certain civil and constitutional rights. This is the concept of, in essence, recognizing or bestowing certain constitutional type rights on nature, like the right to exist, the right to flourish, the right to thrive, for a river to have a right to flow. But basically these broad standards that have developed around human civil rights type protections being applied to nature, not because it's the right thing to do, which it is, not because the moral or ethical thing to do, which it is, but because the survival in many ways of the human race depends on this concept that we understand that we're connected to everything, that we're not separate and apart, that we're reliant on this system that provides us with life support systems and with flora and fauna and flowing rivers and mountains and forests that are healthy. And so it's the concept of marrying up a new legal system with that understanding, because otherwise we are in a crisis moment right now, whether it's climate change or the fact that we've mowed down 90% of the original forests in the United States, or we continue to pump 4 billion tons of toxic pollutants into the air illegally each year. No matter how you look at it, the old system that we have just isn't working anymore. So for folks interested in it, not only as a kind of moral and ethical movement, as well as a legal movement, that people are interested in it for different reasons, but it doesn't matter. It's all connected to the same, which is that survival on this planet demands that we switch to a different kind of system.
Thanks. That's an outstanding and really very clear explanation, one of the best I've heard. Now that you've introduced the idea conceptually, can you bring it down to earth and give us an example of how it's being applied, rights of nature? We talked about, Klamath being possibly one example that you are knowledgeable about.
Yeah, so I'll talk about two, one indigenous and one non-indigenous. And the non-indigenous example I'll use is that in November of last year, 2020, the people of Orange County, Florida, which is where Orlando is located, it's the 30th largest county in the United States. It's about 1.5 million people, so a good-sized big county. That environmental activists were frustrated by this existing system of law, which basically has put Florida into a water crisis situation, whether it's die-off of marine life or red tides or algae blooms. Florida's in a pretty bad situation right now, a crisis situation around water quality. And it's kind of been the responsibility of the state, who's been passing out development permits, like candy at Halloween. So 23,000 permits have been issued by the State Department of Environmental Protection to polluters that are polluting waterways and air and polluting the soil as well. And so activists in Florida said, we're not going to do this anymore. We're not going to go to hearings where we're not even sure whether the microphones are even plugged in or not, or where we're given 30 seconds at a meeting to explain what's happening and to try to find a different way, or begging and pleading regulators to do something differently. And instead they moved to draft a new law. And that new law recognized rights, legally enforceable rights for the Wekiva and Econlockhatchee rivers in Orange County, two of the main rivers that flow through the county. And those rights included the right to be free of pollution, the right to flow, the right to maintain a healthy ecosystem, those types of rights that accrued not to humans necessarily in Orange County, but accrued to the rivers themselves. And that initiative, which I think most people didn't think had a shot at passing, actually received 89% of the vote in November of 2020, thus becoming the law of the land in Orange County. And then the next step is to enforce these, because it doesn't matter what you pass if they just sit on the books. You have to actually enforce them. And so back in May of this year, there was an enforcement lawsuit filed against a developer who wanted to put in a 1,900-acre housing commercial development that would destroy over 100 acres of wetlands. So you have the Orange County law, which says wetlands have rights, including a right to life, right to exist. You have a developer trying to build a development in which he wants to destroy 100 acres of wetlands. There's a clash of systems there. This kind of indigenous-driven value system that's now been driven into Western law versus the existing system, which wants to permit the 1,900-acre housing development and destroy the wetlands. So that's a real-life example of how these laws get enforced. It's not just about passing them. It's actually about changing behavior involuntarily of those entities that have no interest in voluntarily changing their behavior. This is about actually putting in place a different rule, and that rule can be enforced in courts. And then the indigenous example that comes to mind is the Yurok tribe. Randy, as you mentioned, the Klamath River. The Yurok, several years ago, passed a law, one of the first round of laws passed by indigenous communities in the United States, to recognize the Klamath River as having certain rights. So again, just like the Orange County example, this is about a river having rights to exist and flourish, constitutional-based standards. And the interest of the Yurok tribe, of course, the Yurok Nation, is to protect the salmon. So protect the river as a waterway, of course, but also protect the salmon. Salmon runs are down, in some places, 95% for the Yurok tribe. Salmon is a critical piece of the Yurok Nation's identity. And so protecting the waterways to protect the salmon, a critical piece of that cultural heritage that the Yurok Nation has. And of course, the Yurok talk about the Klamath River being a living being, a relative of Yurok members. And that's similar to some of the other tribes that have passed these rights of nature laws, like the White Earth Band of Chippewa in Minnesota. They passed a law in 2018 to recognize wild rice, or Monoman in Chippewa verbiage, Chippewa language. Monoman is having certain rights to pure water habitat, to exist, flourish, thrive. And again, wild rice, of course, is one of those closely held heritage cultural items for the Chippewa, just like the salmon is for the Yurok. And for the Chippewa, of course, the rights to gather wild rice are protected by treaty. So not only on reservation wild rice, but off reservation wild rice as well, because the right to gather rice is protected by a federal treaty. Because of that, you have to have a resource there to actually gather. Otherwise, the treaty rights make no sense. So from an indigenous perspective, coming at it from core cultural values embedded in indigenous communities, for non-indigenous communities, coming at it from a failure of a traditional European regulatory system to actually protect the environment. So kind of frustration on both sides, but both ends driven by the same, driven towards the same model, which recognizes these legal rights for ecosystems, not just for people.
I really appreciate both examples. They're nicely complementary. I'm going to back up because I suspect that many of our listeners are having to take a deep breath and scratching their heads saying, I really intuitively get the part about, the wolf and the hawk and those other living beings being animate and being persons. But somewhere along the way, I kind of wandered off the path when suddenly the landscape became animate and has personhood. You explained it nicely, but I'm actually going to ask you to re-explain both the legal and environmental import of that, and again, how this is deeply connected to indigenous spirituality and thinking, because that part is a little bit of a leap for people in the mainstream. And even some people like myself, who I'm a legal tribal member, but I didn't grow up on the reservation. I didn't grow up with people using an animate language every day, which reminds me every day and every word that there are many, many animate beings out there. Could you re-explain it again for us?
Yeah, I think indigenous communities, of course, have a connection to land that non-indigenous communities, Western communities in the U.S. Particularly don't have. And so that connection to land really evidences in two ways. One is connection to those resources that are necessary for the tribe, both culturally as well as from a survival standpoint. So that's like wild rice for the Chippewa, salmon for the Yurok tribe, et cetera. And so that connection to the land may evidence itself through a use of a resource that's critical to the tribe's survival or critical to the tribe's culture. But the growth of these laws is also coming from the traditional environmentalist wing of activism in the United States, especially, which is driving towards greater protection of ecosystems themselves, such as land or forests. I have to say the early rights of nature laws that were passed in the U.S. back in 2006 covered all ecosystems. A little place called Tamaqua Borough in Pennsylvania became the first in 2006 to pass the law. And that law protected all ecosystems in general. The laws since then have really begun to narrow themselves down to specific pieces of those ecosystems, and mostly waterways. So what you see now is mostly rights of nature seen through waterway protection or rivers. So that river ecosystem is being kind of a discrete, boundaried ecosystem that's easy to identify and also assign rights to or bestow rights to. So I think that's what you're seeing more and more. The Ecuadorian Constitution, which was really the landmark moment when we were in Ecuador assisting with the drafting, it was very clear from the delegates that were drafting the Constitution that they wanted to protect this concept of good living, and that the constitutional amendment was driven, the rewrite of the Constitution was driven by the indigenous communities in Ecuador who wanted to protect land as an ecosystem, as well as discrete parts of that land like species or waterways, those types of things. So there's no linear A to B here pretty much, but this concept that nature has rights extends beyond just waterways and species to this concept of land, but hasn't really been practiced that much in the U.S. In terms of that broader ecosystem protection, more of discrete resource protection.
So we have just a little bit of time left here in the first segment. I'm going to pose a question and give you a moment to think about it. You're so terribly articulate. I shouldn't say terribly. You're so wonderfully articulate on this topic. And I think I'm correct in saying you didn't grow up on a reservation. So one of the things that I'd like you to do to help our listeners is explain your own journey to discovery of the kind of spirituality and rights of nature worldview, because I think we need to help people take their own steps and not be intimidated by being confronted by people who are already there. So we'll take a break and we'll come back and we'll pick up that question.
Citizen Potawatomi Nation's Cultural Heritage Center, located near Shawnee, Oklahoma, features 11 immersive galleries with digital and interactive exhibits. Visitors learn about the tribe's history from origin to modern days and gain an understanding of Citizen Potawatomi oral traditions and lifeways. Admission is always free. Open Monday through Friday from 8 a.m. to 5 p.m., Saturday 10 a.m. to 3 p.m. Visit the Cultural Heritage Center on the web at PotawatomiHeritage.com.
Period poverty. If you don't know what it is, you should, because you can help. 1 in 4 American women struggle to purchase menstruation products this year, resulting in missed school and even loss of income. The Native American women's nonprofit, Queck Society, cares enough to give Native American students and communities their period products, and they do it across North America. Please help women with your time, donations, or supplies to maintain their dignity and celebrate their strength during moon time. Visit quecksociety.org. That's KWEK Society.org.
Listen up. The source for information and inspirational items about the struggle and wisdom of indigenous people is the Syracuse Cultural Workers. They are committed to peace, sustainability, social justice, feminism, and multiculturalism, and they create beautiful visual materials like calendars, t-shirts, cards, and more, including their greetings and thanks to the natural world accordion poster that offers daily grounding for our relationship to the earth and its many fellow beings. Get so many wonderful items. Go there now. SyracuseCulturalWorkers.com.
Randy Krakowski's book, Without Reservation, describes his spiritual awakening as a Native American. It's a powerful, life-changing story where Randy shares his journey into the realm of ancestral Native American connections and explores his encounters with Mother Earth. The book actually helps you how to reconnect with your ancestors to rekindle your access to ancestral wisdom and nature. Available in print, ebook, and audiobook format, Get Without Reservation by Randy Krakowski from all major booksellers. For more information, visit randykrakowski.com.
Feel you have no control over life? There's something you can do to make a difference for you, your family, and community. Stay positive and take a break from the dark side. Uplifting and enlightening. Listen to the positive side of podcasts. hrnradio.com.
So, welcome back to Indigenous Perspectives. Our guest is Thomas Linzey, and we left him with a question in the first segment about how he could help us to understand his own journey to where he now is working in the legal profession nationally and globally. Tom, can you try to answer that question for us?
Sure. So over the past 20 years, we've run into people who have come to similar conclusions to the ones that we've come to along our path, our journey, about how the existing system of environmental law isn't actually protecting the environment. As funny as that sounds sometimes, that we have an environmental protection system that isn't actually protecting the environment. But my journey started with an embrace of that conventional environmental regulatory system. So coming out of law school, we created a law firm that provided free legal services to community groups fighting toxic waste landfills and incinerators and fracking and large-scale water withdrawals. Basically, any of the thousands of unwanted projects, mostly corporate projects, that are thrust onto communities every day in the United States, every day, every week. And I spent a decade trying to enforce conventional environmental law. So we litigated the Clean Air Act, the Clean Water Act, the Endangered Species Act, the National Environmental Policy Act, this acronym soup, that we have in the U.S. around environmental laws. And so we spent 10 years trying to enforce those laws. And what we found was that the laws themselves don't really give any power to communities to reject these projects. In fact, in the U.S., the law is that if the federal or state government have permitted something, issued a permit for a specific use or project, that the municipality or the community has no power to prohibit it or reject it. That's black letter law. And so time and time again, we ran into these corridors where, the major corporations in individual industries will write the environmental regulations. It's the secret nobody really wants to admit. But the large corporations write the regulations. So why would they provide anything in those regulations for communities to actually stop projects? And so I would find myself in hearings in front of judges arguing over permits that had been issued, and we would win those fights in front of those judges. But then the corporation would simply come back and either rewrite the regulation or take the gas emissions and deficiencies that we had found within the permit application they had filed and fill those in. And so we had some of the biggest law firms in the country come up to us after these hearings that we had won on behalf of our community clients and actually thank us for finding the gas emissions and deficiencies in the permit application so that they could then bill the company more hours to go back and fill in the gas emissions and deficiencies. And the other thing that you learn the hard way is that the corporations, at least we thought we were forcing the companies to expend money to defend the permit challenge that we had filed. But in the end, one thing you learn is that the permits challenges, the defense by the company of the permit challenges, the monies that they spend is tax deductible. under the tax code as a reasonable and necessary business expense. And so the final part of my learning came when a woman named Jane Ann Morris, who used to bill herself, she's passed away, but used to bill herself as a corporate anthropologist, looking at the history of corporations and the pathology of it, said to me that the only thing environmental regulations regulate is environmentalists. That the only thing environmental regulations regulate is us, because they make us predictable as to how we oppose projects when they come into our community, because the script has been written for our opposition before the company even sets foot into our community. We've lost before the company even comes in because the industry has written the regulations underneath which we're trying to do defense. So long story long is that it took 10 years of that kind of churn for me to come to a conclusion that the environmental system was, a lot of people say, broken. It's not really so much that it's broken to the point where it's operating perfectly for some. It operates to exhaust us on a hamster wheel of activism, while there are others in control of the script underneath which we're doing our activism. And so a lot of environmental lawyers, or some, a small handful, come through that pathway. The other pathway is activists on the ground, communities who have been fighting stuff for 30 or 40 years, who have come to the conclusion that the whole thing is just a hamster wheel intended to exhaust communities, which it does really well, and have started looking for a different system. And so, those are kind of the different pathways. But I think my education reached the graduate zone when I was teaching a class on how the environmental regulatory system works, and that municipalities, cities, towns, villages, and counties, and people who live within them, don't have power to say no to these harmful projects coming in if the state or federal government has issued a permit. So state or feds have issued a permit. The community has zero power to prohibit that incinerator, or zero power under conventional law to prohibit this particular project coming in. And the class I was teaching was indigenous as well as non-indigenous. And the indigenous person stood up and said, "Oh, so we're not the only ones that live on a reservation." that the municipal government structure, because it's so tightly controlled by people further up and further away, sometimes 3,000, 6,000, whatever miles away, that municipal unit is wholly held. It's almost property of the state and federal government. That if you misuse that municipal government to try to ban something that's permitted, like an incinerator, landfill, or whatever that's harmful, the whole system crashes down on you, just like it does indigenous communities that attempt to say no to uranium mining, off-res, that's going to have an impact on reservation lands, or limiting jurisdiction by indigenous communities over non-tribal members, like companies doing X, Y, and Z off-reservation that impact tribal members. So I think that was one of my awakening moments, was to hear that said, because in reality, it's tough to compare a white white European community with all the privileges that come with that to an indigenous community and call them both reservations. But in reality, they're both reservations because they're held by a system of law that if you agree with the decisions made by the system of law, everything's fine. But when you start to disagree, that's when the system crashes down on you to stop you from doing what you're trying to do.
So at some point in this epiphany, was there also a moment when the spiritual dimension of what the Native Americans were saying to you clicked in and began to inform your work?
I think that took a lot longer. I mean, I'm as English as English can get. So Scotch, Irish, and English. I mean, my family has a coat of arms and a town named after us in England. And so, that stuff's really deeply embedded. And I don't think that kind of awakening or that kind of journey started until we began working with indigenous communities, because the rights of nature work started in non-indigenous Western communities. It was birthed by having another tool to stop a project from coming in. How do we use this tool? But working with the Ho-Chunk in Wisconsin, working with the White Earth Band, the Yurok Nation, the tribes across the U.S. that have really begun to be the front cutting edge of rights of nature work. I think working more and more with tribal lawyers, seeing a different vantage point, and understanding that the cultural value is one of those things that's so deeply embedded, that is a driver for this work, that it gets encapsulated in how you argue in court, gets encapsulated as that how you talk to people, but I'm done waiting for some kind of spiritual conversion by a majority of the Western communities. We're kind of, I'm not hoping for that anymore. What we're hoping is that these tools speak to different communities in different ways, and indigenous communities have the biggest claim to this concept, overarching framework. So I think it's going to move quickest there.
Wow. We're going to take a break, and we'll be back with Thomas Linzey for our next segment. Stay tuned.
Located near Shawnee, Oklahoma, Citizen Potawatomi Nation is Potawatomi County's largest employer with a rich history and culture as a sovereign Native nation. Learn more about CPN by visiting its website, which includes information on services for members, tribal enterprises, government and constitution, the newspaper, and much more. All at Potawatomi.org. That's POTAWATOMI.org.
Randy Krakowski's book, Without Reservation, describes his spiritual awakening as a Native American. It's a powerful, life-changing story where Randy shares his journey into the realm of ancestral Native American connections and explores his encounters with Mother Earth. The book actually helps you how to reconnect with your ancestors to rekindle your access to ancestral wisdom and nature. Available in print, ebook, and audiobook format. Get Without Reservation by Randy Krakowski from all major booksellers. For more information, visit randykrakowski.com.
Since 1975, Inner Traditions has been publishing books for the healing and spiritual journey. Their mission is to rediscover, preserve, and protect these spiritual traditions of the world so that humanity will forever have the tools to create a better future that will celebrate and heal the earth. Inner Traditions books, card decks, and other products are available wherever books, ebooks, and audiobooks are sold. Or visit InnerTradition.com's online bookstore. And while you're there, sign up for their free newsletter to receive special offers. That's InnerTraditions.com.
Period poverty. If you don't know what it is, you should, because you can help. 1 in 4 American women struggle to purchase menstruation products this year, resulting in missed school and even loss of income. The Native American women's nonprofit, Queck Society, cares enough to give Native American students and communities their period products, and they do it across North America. Please help women with your time, donations, or supplies to maintain their dignity and celebrate their strength during moon time. Visit quecksociety.org. That's KWEK Society.org.
Don't get angry. Anger is a negative emotion that suppresses your immune system that may cause health problems. Make a positive difference by working together to protect and support your family, friends, and community. Take a break from the dark side. Uplifting and enlightening. Listen to the positive side of podcasts. HRNradio.com.
Welcome back, Thomas Linzey, to the third segment. And can you switch your attention now to talk about some of the ways that rights of nature has gained a lot of traction in the international world and in different countries outside the United States?
Yeah, so enforcement actions in the U.S. have been pretty sparse so far, but development of the rights of nature concepts and jurisprudence in other countries has moved rapidly forward. Starting with Ecuador, 2008 new constitution in Ecuador, adding rights of nature principles, becoming the first country in the world to recognize rights of nature in their national constitution, overwhelmingly ratified by the Ecuadorian people, opposed by the Catholic Church. One of the leaders in the opposition was the Catholic Church, arguing that rights couldn't be given to nature because it was a human concept. So that was some of the opposition in Ecuador. And also opposition from some mainstream environmental groups that thought rights of nature was too radical, too crazy, too fringe, and would undermine their use of the environmental regulatory system within Ecuador. So interesting kind of opposition points. In Ecuador, there's been over 60 enforcement cases. So administrative, judicial, The first case was the caption, the Vilcabamba River versus Province of Loja. The name isn't important except to note that the river itself was the plaintiff. So in these cases, humans are not the plaintiffs. Humans are the voice of the river in this case, but the river is the plaintiff. And that kind of avoids the scrutiny as well that legal standing brings. Generally in court, you have to be injured as a human to bring a case. And so when you're a plaintiff, one of the arguments by the other side is to dismiss the case because you don't have standing, you haven't been injured by whatever's happening. Well, in these cases, the ecosystem is the plaintiff, which means that the focus of the standing inquiry is the ecosystem itself, which is being damaged, rather than the humans who are basically acting as a trustee or a guardian for that particular ecosystem. So whether it's shrimp farming, shark finning, protection of mangroves, in Ecuador, you've had both criminal and civil enforcement actions using rights of nature laws in all of those cases. The Vilcabamba River case, which was brought in 2011, first case in the world in which a judge held on behalf of an ecosystem in a rights of nature case. So in this case, ruled in favor of the Vilcabamba River, ordered the local government to stop dumping road debris into the river, which was changing its course and flow. But that was the first case. So about 60 enforcement administrative cases as well as judicial cases in Ecuador. Constitutional Court of Ecuador, which is the highest court interpreting the Constitution, has selected now some cases to issue new decisions on rights of nature, which we expect to be a bright line kind of interpretation, further interpretation of how rights of nature can protect against mining, biodiverse areas, forests, those kinds of things. So we're watching that happen. And up till the Ecuadorian example, we expected most of the work around the globe to be legislative. So whether these would be local communities or national governments writing rights of nature laws and then having the courts enforce them. That had been the process up until this time. So writing laws, having courts enforce them. In 2016, that changed. The Colombian Constitutional Court, looking at a case dealing with the Trato River in the country, no laws whatsoever, no legislation whatsoever, instead used rights of nature principles from the bench. So judges taking rights of nature principles from Ecuador and other places declared it a new norm of international environmental jurisprudence. So a new legal norm, and then applied it to give rights to the Trato River, to the Rio Trato in Colombia. So no legislation, no laws had been passed. These were judges taking concepts and applying them directly in the courts. In 2017, a court in India followed suit, recognizing the Ganges River as being a legal person, basically a rights holder, and then what rights that the Ganges had. 2018, the Colombian Supreme Court followed the lead of the Constitutional Court and ruled that the Amazon River had certain rights, and the Amazon River basin was a subject of rights. So not just the river, but the basin itself is part of that watershed and ecosystem. And in 2019, the High Court of Bangladesh, which is the Supreme Court of Bangladesh, recognized legal rights for all rivers within the country. So not just a single river, but all rivers within the country as being subject of rights and having certain rights. So at the international level, it's been very interesting because the process of legislation and enforcement has been bypassed, and courts are now applying it directly based on the principles that are coming out of the Ecuadorian courts and out of this kind of frustration with existing environmental regulatory systems, wanting something that's much clearer, shifting nature from being property into being rights holders, essentially, under those systems of law.
Several of the societies that you mentioned are societies where a significant portion of the population intuitively and historically understands that nature is animate and that we are on an equal footing with it. That's an enormous advantage. We don't have that advantage so much here. Is that an obstacle to moving forward with rights of nature in our legal system?
I think it is. I would also say that when you talk to folks in Bangladesh, India, and Colombia, they would explain to you that it certainly hasn't been a downhill ride for them, because the legal systems that are put in place in those countries, which are all colonized countries, were basically colonial legal systems which were superimposed. and we do it today. The U.S. sends lawyers out to other countries to replicate our environmental regulatory system. So these other systems of law are not the easiest to navigate. Even in Ecuador, you've had arguments about nature being property, that rights of nature, the arguments at least can't ascend above or be elevated above property rights within the system. So especially in Colombia, which has this really up to, historically has had a really colonized kind of judicial structure. So in each of those countries, the litigants, the plaintiffs in these cases mostly have been environmental groups or community environmental organizations, have had to override that bias within those systems to actually obtain these rulings. So I think there's a lesson there for the U.S. I think some of the international jurisprudence may boomerang around to U.S. courts. But in some ways, for now, we've given up hope that Western courts are going to be able to deal with what's in front of them, because folks think about courts as neutral, but they're not. They're dependent and restricted by precedent over the last 200, 300 years. That is the importance of property within that system. So I think the place where new stuff is going to happen first is probably tribal courts. So indigenous communities that have their own courts that are enforcing a different value and culture system than Western courts, whether those be local courts, state courts, or federal courts within that Western system.
That's a really important point to end on for this segment, and we'll pick it up at the beginning of the next segment when we'll discuss a bit more about the long-term prognosis for rights of nature and the importance of tribal courts in the United States.
Citizen Potawatomi Nation's Cultural Heritage Center, located near Shawnee, Oklahoma, features 11 immersive galleries with digital and interactive exhibits. Visitors learn about the tribe's history from origin to modern days and gain an understanding of Citizen Potawatomi oral traditions and lifeways. Admission is always free. Open Monday through Friday from 8 a.m. to 5 p.m., Saturday 10 a.m. to 3 p.m. Visit the Cultural Heritage Center on the web at PotawatomiHeritage.com.
Period poverty. If you don't know what it is, you should, because you can help. 1 in 4 American women struggle to purchase menstruation products this year, resulting in missed school and even loss of income. The Native American women's nonprofit, Queck Society, cares enough to give Native American students and communities their period products, and they do it across North America. Please help women with your time, donations, or supplies to maintain their dignity and celebrate their strength during Moontime. Visit quecksociety.org. That's Kwek Society.org.
Listen up. The source for information and inspirational items about the struggle and wisdom of indigenous people is the Syracuse Cultural Workers. They are committed to peace, sustainability, social justice, feminism, and multiculturalism, and they create beautiful visual materials like calendars, t-shirts, cards, and more, including their greetings and thanks to the natural world accordion poster that offers daily grounding for our relationship to the earth and its many fellow beings. Get so many wonderful items. Go there now. SyracuseCulturalWorkers.com.
Randy Krakowski's book, Without Reservation, describes his spiritual awakening as a Native American. It's a powerful, life-changing story where Randy shares his journey into the realm of ancestral Native American connections and explores his encounters with Mother Earth. The book actually helps you how to reconnect with your ancestors to rekindle your access to ancestral wisdom and nature. Available in print, ebook, and audiobook format, Get Without Reservation by Randy Krakowski from all major booksellers. For more information, visit randykrakowski.com.
Where positive people and radio unite. HealthyLife.net.
Welcome back to Indigenous Perspectives and our guest, Thomas Linzey. This is our final segment. And we're going to wrap it up with a big question, which is, where is all this leading in the long term? And what reasons do we have to be hopeful about the rights of nature making a difference?
Yeah, it's a great question. It used to be 20 years ago when we talked about rights of nature that they would put you in a padded room. So I gave a tour of law schools in the United States with a South African lawyer. And about halfway through the presentation on rights of nature at the law schools, we would have the environmental law professors get up and leave the room because there are whole careers and, there's a lot banked on this environmental regulatory system that's developed in the U.S. And at least back then, some folks felt that rights of nature was a real threat. But that's a real threat to the basis and kind of crazy and fringe. But that's since changed. I mean, you have 3 law schools now, Tulane in New Orleans, Vermont Law School, Levin College of Law in Gainesville, Florida, which have held symposia on rights of nature now, where law professors, deans have spoken. It's basically becoming a more acceptable part of the discourse. Democratic Party of Florida has now put rights of nature plank into their platform for the Democratic Party. The Democratic National Committee has also did so 4 years ago, supporting indigenous communities that were passing rights of nature laws. And all of this cultural understanding, this kind of embrace of some of these concepts, there's been a backlash as well. In the states of Ohio and Florida, the state legislatures have now passed preemption laws, which prohibit cities, towns, villages, and counties, municipalities from passing rights of nature laws at the local level. So now the lawyers are trying to figure out ways to override that preemption in different places to continue to pass those laws. But getting all the way back around to the question, what's the long term here? I think the short long term is that more tribal laws are passed, amending tribal constitutions, passing them within business committees of tribes as regular tribal laws, and then moving into tribal courts to enforce those. One of the most exciting cases is brought right now by White Earth to protect wild rice on the White Earth Reservation in Minnesota. So that's the first enforcement case that's been filed about threats to wild rice. So I think there needs to be more of those, hundreds of those rather than just a handful. And then moving municipal laws at the local level. People don't need to wait for lawyers to hold their hands. They can move these forward themselves. In the U.S., most municipalities have initiative processes so that if you want to get something passed as law in your city, you can actually collect signatures, go over the heads of your elected city council, and put the laws in place on through the ballot. That's what the Orange County, Florida folks did. So I think there need to be 1,000, 2,000, 3,000 of these laws running to, in effect, change the law from below and begin to create these confrontations between the tribal courts and the regular courts or municipal courts and the people of a municipality. These confrontations help people understand why the existing system is so deficient and why a new one is needed. So kind of like building a new bridge while you're beginning to demolish the old one. So there needs to be many more of those new bridges. And then the thing that excites us a lot is that in Florida, they're now circulating petitions statewide to qualify state constitutional amendments, which would recognize rights of nature, specifically rights of waterways in one amendment, rights of iconic species in the other. So like the Florida panther, the manatee, the right whale, the bottlenose dolphin, iconic species in Florida that would be recognized as having their own rights. So bestowing these constitutionally based rights on species within Florida as well as on waterways. That's very exciting. And qualification at that level is very difficult. It takes about 1 million signatures in Florida, so it might be another cycle after this one that it takes. But just that people are thinking about how do you take that local level of law and actually use it to change those higher levels of law is extremely important. And then we've been involved in a thought exercise about what a new federal constitution would look like that actually codifies rights of nature into the constitutional structure at the federal level, which of course is this huge mountain to climb, uphill battle kind of thing. But after all, Ecuador has it in their national constitution. So it's not so foreign to that concept. But also the U.S. Constitution was written back in the 1780s. It's almost like, Microsoft Word 1.0. And we have this 1780 system of law, which is based almost entirely on property protection. You won't find the word environment or nature anywhere within the U.S. Constitution. You won't find the words organized labor. You won't find the word union. None of that stuff exists in the 1780s Constitution that we have. some of us have been thinking it's time to upgrade that U.S. Constitution so that it's actually an earth-centered or a nature-centered, a survival-centered kind of document, which means overhauling the U.S. Constitution, maybe amending it, writing a new one. But I think what you're seeing right now is a movement of people, communities, towards those goals, building the local, using the local to change the state, and then hopefully using the state to actually galvanize a conversation about what kind of structure we want to be governed under. And I think that federal constitutional structure has been used as a weapon against indigenous peoples, against organized labor, against environmental activists and nature itself. We don't see the Constitution sometimes as a weapon against the things that we love, because it has good stuff in it like the Bill of Rights, but we forget that the Bill of Rights had to be driven in over the objections of the people that wrote the Constitution in the first place. So even that was revolutionary. So how do we keep the good? How do we throw out the bad? But how do we have a national source code, a DNA, that actually supports the good stuff and the right stuff, rather than continuing to be used as a weapon against the work that activists, both indigenous and non-indigenous, need to be doing?
Thomas, we're deeply grateful. Miigwech and Potawatomi, thank you for the wisdom and the perspective and the effort that you bring to this endeavor. It is truly a reason for great hope. And I want to acknowledge immense gratitude for what you and your colleagues and your allies around the country and the world have done. So to our viewers, I also want to say, Miigwech, thank you for listening. I hope that this broadcast has given you time and space to reconnect with your roots in Mother Earth and with your ancestral roots. Before your busy day distracts you from this moment, I encourage you to take a few minutes to reach out and feel the presence of living flora and fauna, and perhaps even that of ancestors. Allow yourself to touch their presence, capture that moment, and hold on to it. And if you might, write to me and let me know about your experience. I can be reached at randykwiatkowski@hushmail.com or through my website, randykwiatkowski.com, where you can also find transcripts and supplemental materials of Indigenous Perspectives radio programs like the one you just listened to. And it will allow you to read as well as listen. Again, thank you very much.
Located near Shawnee, Oklahoma, Citizen Potawatomi Nation is Potawatomi County's largest employer with a rich history and culture as a sovereign Native nation. Learn more about CPN by visiting its website, which includes information on services for members, tribal enterprises, government and constitution, the newspaper, and much more. All at Potawatomi.org. That's POTAWATOMI.org.
Randy Krakowski's book, Without Reservation, describes his spiritual awakening as a Native American. It's a powerful, life-changing story where Randy shares his journey into the realm of ancestral Native American connections and explores his encounters with Mother Earth. The book actually helps you how to reconnect with your ancestors to rekindle your access to ancestral wisdom and nature. Available in print, ebook, and audiobook format. Get Without Reservation by Randy Krakowski from all major booksellers. For more information, visit randykrakowski.com.
Citizen Potawatomi Nation's Cultural Heritage Center, located near Shawnee, Oklahoma, features 11 immersive galleries with digital and interactive exhibits. Visitors learn about the tribe's history from origin to modern days and gain an understanding of Citizen Potawatomi oral traditions and lifeways. Admission is always free. Open Monday through Friday from 8 a.m. to 5 p.m., Saturday 10 a.m. to 3 p.m. Visit the Cultural Heritage Center on the web at PotawatomiHeritage.com. Remember, help for a positive life. www.healthylife.net.